New revelations show the National Security Agency's surveillance program violated its own privacy rules. The Post reported that the NSA has overstepped its authority thousands of times each year since Congress expanded the agency's scope and power in 2008. The NSA pushed back, saying the breaches were unintentional and, for the most part, minuscule. Joining me now via Skype is Barton Gellman, Washington Post contributor and senior fellow at the Century Foundation. Thank you so much, Bart, for being here. We're going to go first to President Obama. Earlier this month, he commented on the NSA surveillance program at a press conference. Let's take a listen.
What you're not reading about is the government actually abusing these programs and listening in on people's phone calls or inappropriately reading people's emails. What you're hearing about is the prospect that these could be abused.
Bart, what do you make of what the president said there?
The president, like a lot of people who work for him, has a very narrow definition of two key words in that passage. One is abuse and the other is inappropriately. As the government depicts it, and this is language it's using that it does not, frankly, explain. Abuse, the only kind of abuse that exists would be if, say, an NSA employee were to stalk his ex-wife or spy on movie stars or something of that nature. If they are performing the mission that the NSA wants them to perform and nevertheless overstep their legal authority, make unauthorized interceptions or searches or retentions or sharing of secret information, that is not abuse. That's a mistake.
Okay, and what did you find in your reporting, the sort of mistakes they were making and the reason for the mistakes?
Well, let me just start with the biggest picture here, which is that you get a portrait of the NSA as a flawed organization, like any organization that does the wrong thing on a fairly high number of occasions every year. What you see is a very strong contrast to the picture that has been painted by the administration, by the intelligence community, of thick layers of oversight and safeguards sufficient to guarantee that they're not going to overstep their bounds. And they also portray a degree of oversight by Congress and by the courts that simply doesn't exist.
And they have said that if you take a look at the entire picture, these mistakes that turned up in these audited, something like overstepping their authority, over 2,000 times, in the context is 20 million or so searches a month.
Right. Look, if you were evaluating an employee and based on error rates, then getting something on the order of 0.01 or 0.001% mistakes would look pretty good. For most citizens, the number that matters is the absolute value. It's a little bit, to take a not perfect example, like checking your bags on an airline flight. Let's say there's 1 billion passenger flights a year and they only lose 1%. That's 10 million. Losing 10 million bags is a big deal, even if they have a 99% success rate.
Especially when it's your bag, right?
Right, it's your bag, and it's your privacy, and it's your information that has been unlawfully or collected without legal authority, at least. And it's not all sort of trivial human error.
Which is one excuse they have given, that is trivial human error. What are the reasons for these errors? Some of them, you say like 1 in 10 is typographical.
Yeah, 1 in 10 of the human-caused sort of infractions are typos. I mean, that can literally be sort of fat-fingered search terms or clicking the wrong button into one database when you mean to click into another. Nevertheless, information is collected. If in those cases, the information is usually removed from the database, but not always. They can ask a supervisor for permission to keep it and share it if it turns up valuable intelligence as they see it, or evidence of a crime, and so on. And by the way, most of the collection on U.S. persons, which is Americans and green card holders and U.S. companies, does not come from mistakes like that. It comes from what they call incidental collection, and that's a thing they almost never talk about in public. It comes when they are targeting a legitimate foreign target, even if they know they'll pick up lots of American content in the process. And the American stuff comes in just as the inevitable result of targeting the foreigner. In those cases, they get to keep it all. They typically store it with the names masked, but it is routinely possible to unmask the names when distributing the information.
And there's also a technological problem that possibly can't be overcome, at least not yet, which is that this technology, even though it can sweep up vast amounts of information, it can't determine whether a foreign mobile phone has actually entered the United States.
Yeah, the biggest class of technological mistakes comes from that. They actually, for some reason, only get quarterly reports of where a GSM mobile phone is in the world. Now, this is and so you're monitoring a foreigner using a telephone in China.
Right.
The person flies to San Francisco, and you're still monitoring. That's against the law under FISA without a specific warrant. But they only find out every 3 months where the phone is, and they find out sooner if someone says, here I am down at the at the waterfront in San Francisco, and they say, oops. Now, this is also nevertheless a reflection of a systemic issue and a reflection of priorities. It is not beyond the capability of the NSA to know where in the world a phone is lighting up.
Right.
I mean, the phone company certainly knows.
Yeah.
And the NSA has a pretty good window on that. If it wanted to spend the resources and priorities to synchronize those systems, it's hard to believe it could not do so. But there are other kinds of technical issues. In general, they give greater weight to collection than to protection of information that they should not be collecting. Otherwise, they could adjust the filters, so to speak. They're immensely complex systems,
Right.
but there are safeguards that could be built into them, the automated collection that are not being built in.
Talking to Barton Gellman about the NSA surveillance program and an audit that found thousands of security breaches, is it your sense that we would be here talking about this were it not for Edward Snowden?
Well, clearly we would not. I mean, even after the immense number of revelations that have already taken place since early June, the president came out and, as everyone else speaking for the administration has come out, and talked about the safeguards that make it, next to impossible to collect information that they're not supposed to collect. Now, they're using a sort of a private form of words that focuses on what their own assessment is of abuse. But I would give you another example. The president or the administration twice a year releases a report to Congress that has statistical information on what they call compliance incidents. Congress gets the whole thing, although very few people are allowed to read it in practice. But when it has been released under freedom of information laws, you get a headline on top that says statistics on compliance incidents, and every single thing below that is blacked out. They won't give you any information that's bigger than a bread box, no numbers whatsoever. So only when the statistics come out can you even begin to address what's going on.
And so Obama, in that same speech that or press conference that we showed a clip from, he has promised more safeguards, more oversight, more transparency, and that he would outline a legal justification. Is that going to help? Is it your sense that that will address the issues that you've uncovered here in this audit?
Well, I mean, the first steps of transparency have been a lengthy defense legally of the grounds of collection of every single American's phone records. And whereas earlier the president expressed a willingness, and so did the NSA head, to change that program, to add privacy protections, this new document, released under transparency, takes a pretty aggressive stance about why it's necessary and completely legal. So in some respects, that transparency was a step backward in terms of policy reform.
Now, Chris Van Hollen, he has recently suggested a citizen's advocate to safeguard Americans' privacy. Here is what he had to say.
Right now, you have to have a reasonable suspicion that that phone number was involved in terrorist activity. My concern is NSA can reach that judgment unilaterally. They do not have to get advance notice from the FISA court. So I propose that before they do any kind of query, any kind of search, They have to go to the FISA court. And at that step in the process, we also have what's considered a citizen's advocate to take the adversarial position before the FISA court. So you have that give and take.
You said in some of these instances that the FISA court didn't even know about some of the procedures that were in place until, months after they had actually been going on. So would the kind of steps that Chris Van Hollen is outlining there actually make a difference?
Well, there are two issues. Before the FISA court.
Right.
One is that by nature these are ex parte proceedings. That is to say, only the government is represented, and everything that goes on there is a highly classified secret. And Obama has expressed some willingness in what he calls appropriate circumstances to have a party representing a potentially opposing point of view, a lawyer whose job would be to test the government's arguments and evidence. It's unclear how routinely the administration is prepared to have that happen. The other issue is whether the FISA court has the means independently to assess the government's compliance with its orders.
Okay.
And the chief judge of that court, speaking for the first time ever in public, told the Washington Post's Carol Leonnig that he does not have that ability, that he relies entirely on the government to report its own mistakes. Only then will he delve into them as best he can and look for assurances that those mistakes are being fixed. And so the idea that the FISA court is exercising fully independent oversight just isn't the case. And likewise, Congress finds out what the administration wants to tell it. The
Right.
audit report that I obtained and published in the Washington Post goes into a substantially greater level of detail than anything released to Congress.
And I want to ask you this, and this is sort of a personal question. Do you fear for your own privacy and even safety? Here you are taking on the NSA. You were a little, we couldn't find you over the couple of hours this morning, and we were sort of like, I hope he's okay. What's your sense of that? Are you feeling fine and safe and like your privacy is secure?
Well, I have no reason to think and don't sit around worrying about my physical safety.
Yeah, I'm sure
Mr. Snowden is under investigation
Yeah.
for alleged crimes, and the basis for those crimes includes his contacts with me. So I imagine
Yeah.
I am subject to a greater level of scrutiny than I was before.
Right. All righty. Thank you so much for chatting with us today, Barton. Take care.
Thanks for having me.